Hello, everybody. Hi. Back here today. I've been reading the state's appellate brief for Brendan Dassey. I was reading it and got to the argument section, and I saw some things there that I just had to speak on. So that's what this video is about. It's going to be basically part one, basically the kind of the first part of the argument section, dealing specifically with what is a coerced confession and stuff like that. So I'll probably end up, reading more and more of it and getting more videos ready, and I might just do a couple, parts for this and talk about it. So anyway, I'm going to go over what, basically in this video, I'm going to go over what the state says, coercion actually is, and then what they kind of cite, sort of, and then I'm going to offer my own proof that counters what the state is claiming. So you'll see here coming up. Anyways, here we go. I'm going to go right into the first document here, and you'll see what this has to say. All right. So let's see what the state has to say here. Coercion can be mental as well as physical, according to Blackburn versus Alabama. But only techniques that overcome the defendant's free will are prohibited, such as psychological intimidation or outright fraud. Short of that, the police are allowed to pressure and cajole, conceal material facts, and actively mislead. For example, an empathetic or a fatherly manner by an interrogator does not rise to a level of psychological manipulation. I suppose there's some truth to that, but it also depends on how repetitive they are, I think. But anyways, a lie that relates to a suspect's connection to a crime, such as the strength of the evidence against him, is likely to render a confession involuntary. Merely telling somebody to tell the truth is not coercive, according to the Etherly case. Consistent with these principles, officers are permitted to suggest that the suspect will reap a net benefit from spilling the beans, so long as they do not make specific promises of leniency that amount to outright fraud, which I believe they did with Brendan. Accordingly, a police officer may explain it would go better for you in court if you confess. A comparative attitude would be to a suspect's benefit, such as saying things similar to, like, "I'm going to go to bat for you, do not cross the line," which, okay, that's not a specific promise, so okay, I get it why that doesn't cross the line. But anyways, in general, statements like these are far from threatening or coercive. Now, I basically would tend to agree with that. That they did say I'll go to bat for you or whatever. But the thing is that other statements were made, more specific statements. So we can't just ignore the ones that don't go along with what the state's saying. So anyway, that's all the way I feel about it. Okay, so there was the first document I wanted to share. I'm going to go over that opening sentence there again. Coercion can be mental as well as physical, but only techniques that overcome the defendant's free will are prohibited, such as psychological intimidation or outright fraud. So I look at that statement, and this is what occurs to me. As far as the overcoming of the defendant's free will, Brendan was clearly guessing pretty much the whole time. Okay? Fackbender and Liegert just continued to re-ask their questions, until he guessed something basically that they could work with. And if he was guessing something that they couldn't fit into the narrative that they had already planned, essentially, then it was be honest, Brendan, or tell the truth, Brendan, those sort of things, and that ain't right. But they're allowed to. But I think when it gets to the point where they've said it, ridiculous number of times that they did say it, I mean, that seems like psychological intimidation to me. I mean, it seems pretty valid as intimidation and psychological intimidation, and that then in turn worked to overcome his free will. So I don't know. I disagree on that point that they didn't overcome his free will. But anyways, moving on to the outright fraud. The state claims that Brendan was not made any specific promises, that investigators are allowed to make insinuations and make vague statements about leniency and things like that. But that in this case, they didn't just tell Brendan that they would go to bat for him. Okay, Brendan was told at one point, "You don't need to worry about going to jail. We aren't going to let that happen." That is a very specific promise. Very specific. I don't know. I don't understand how that could be missed, but that's a highly specific promise that was made to him. And if you don't believe that Brendan was told that, then just watch this clip.
Huh? Okay. So why'd you not tell us the truth about when you saw her leaving? Okay, let's get beyond being scared. Let's get beyond the idea of you getting in trouble and going to jail, because it's not going to happen, okay? Tell us anything more. Did you actually see her leave, or did she stay there?
The state indicates that merely telling somebody to tell the truth is not coercive. And, ordinarily, under normal circumstances, I think I might agree with that. But in this circumstance, where it was said hundreds of times, especially with a boy like Brendan, who really doesn't fully grasp the weight of the situation that he's in, it makes it a lot easier, much easier for them to overcome his free will. So it seems obvious to me, but, whatever, to each their own in terms of opinion. So now we're going to move on to the next document. So, the same principles apply to the confessions by juveniles. Relevant considerations include age, experience, education, background and intelligence, the capacity to understand Miranda rights, for instance, the length of a question, the absence or the presence of a parent or other friendly adult. Although juvenile confessions require special care, the Supreme Court has held that a 16-year-old can make a statement intelligently and voluntarily, even without a presence of a friendly adult, which I don't think is the issue personally for me. The issue for me is personally whether or not that, young adult is being treated fairly or getting represented properly. But anyways, accordingly, this court has repeatedly denied challenges to the voluntariness of juvenile confessions, both in the AEDPA and the de novo review. In Etherly versus Davis, for example, the court upheld AEDPA, the introduction of a confession of a 15-year-old illiterate defendant with borderline intellectual functioning who was taken from his home to the police station at 5:30 a.m., interrogated without a parent. The police told Etherly that he had an obligation to tell the truth and that it would go better in court if he helped the police. But they also warned him that they could not promise him anything other than to inform the court of his assistance. Despite Etherly's age, lack of intelligence, and lack of criminal background, the court agreed with the state court that the confession had not been coerced. Okay, so here we have the state pointing out that this court has repeatedly denied the voluntariness of juvenile confessions. He then cites Etherly versus Davis, in which a 15-year-old illiterate defendant was pulled out of his bed at 5:30 a.m. in the morning. He was illiterate. He had borderline intellectual functioning, and he was interrogated without a parent. The police told Etherly he had an obligation to tell the truth, and that it would go better for him in court if he helped the police. But they also warned him that They couldn't promise him anything other than to inform the court of his assistance. That's, so they were pretty honest with him. It's not really the same thing in my opinion here, but hold on. We'll get to that in a second. Apparently this court deemed this kid's confession voluntary. So, that's, somewhat significant, I guess. But here's the thing. Brendan was promised that he wouldn't be going to jail, that wasn't going to happen at one point. He was promised that at one point. Somebody said that. A police officer, a law enforcement officer investigating this case said that to him. So it's kind of like they're arguing apples and oranges here because this case doesn't really fit with Brendan, in my opinion. So anyways, so that's all I've got for now. I'm going to go ahead and cut it off there, and we'll start the next video basically moving on from this point. Thank you for watching, and hit subscribe.